All right, good morning, everybody. If you'll have a seat, we'll go ahead and get started. All right, terrific. Welcome, everybody, to the Cox International Law Center's Conference on Corporations on Trial, which is going to be looking at the criminal and civil liability of corporations for human rights violations around the globe. The timing of this conference could not possibly be better. We picked the topic in part because the chief prosecutor of the International Criminal Court, Fatou Bensouda, announced that it is going to be a priority of her office to be looking at crimes against humanity that are committed by corporations and corporate entities around the globe. And this was a big surprise to a lot of people. Meanwhile, as we were planning for the conference, we found out that the U.S. Supreme Court put on its docket for this fall the case of Jesden versus Arab Bank. And this is a case that involves whether the Alien Tort Claims Act can be used against corporations. And the major defense is that it can only be used against violations of international law. International law can only be violated by states. Corporations aren't a state, so dismiss the case. The Supreme Court is going to have an interesting initial set of hearings on that on October 14th. And we will be talking about both of those subjects today. This conference, like many of the conferences we've had in the past, is only possible because of the generosity of our sponsors. So to tell you who sponsored our conference this year, the primary conference was the Cox International Law Center, which is endowed by the Gun Foundation and is celebrating its 26th year at this law school. We also have the Center for Professional Ethics, the Inamori International Center for Ethics and Excellence, the American Society of International Law, the Cleveland Council on World Affairs, and the Greater Cleveland International Lawyers Group. Our international law program here is one of the gems of our law school. It's ranked 12th in the United States, and it attracts about half of our students, many of which are in the classroom today. I encourage our students to talk with the practitioners, the alums, and the experts that are here to participate in our conference. We're going to have a very exciting day ahead, and it is going to start with a wonderful keynote address by Tom Bergenthal. And so, Tom, if you'll come up, let me introduce you. We've known Tom, well, yes. Mine and a friend of the law school for many years. A decade ago, he came here and was awarded our Humanitarian Award for Advancing Global Justice when he was a member of the International Court of Justice. Tom Bergenthal's career is really exemplary and inspiring. He wrote a book, his memoir, called A Lucky Child, about his early years. He was the youngest person to survive the Auschwitz death camp in World War II. He survived in part because he claimed to be older than he was at a time when anybody, what was it, under 13 or so, was put to death automatically. And luckily you were, at that time, tall for your size, right? So anyway, he went on to come to the United States to be a distinguished professor, to be Dean of American University's Law School, to be the president of the Inter-American Court of Human Rights, to serve on just about every international committee that deals with human rights law, including the El Salvador Truth Commission, which was path-breaking. And right now he's on a similar initiative to look at the concentration camps in North Korea that are currently going on. He was telling me tales about those that are more horrific even than what he said he experienced during World War II. Then, to culminate his career, he was the United States candidate and he was elected to be on the International Court of Justice, where he served for 10 years. He was a very distinguished judge and very independent. Twice he ruled in very important cases against the United States, and as he tells me, nobody in the United States even blinked. That's what they expected him to do when they appointed him, because they knew what they were getting when they picked Tom Bergenthal. He also dissented in some very important human rights cases, including the Eurydia case at the International Court of Justice, which was the case involving whether the Congo Minister of Foreign Affairs could be held responsible for crimes against humanity. And the majority, according to Tom, and I agree completely, wrongly said that head of state immunity would apply to the foreign minister of the Congo for crimes against humanity, which Tom has argued over the years should not be subject to those kinds of immunities. So we are very fortunate to kick off our conference with a keynote about human rights law by one of the giants in the field of human rights law, Tom Bergenthal. Thank you.
Thank you very much. After this introduction, if I had the courage of my convictions, I would sit down. It's wonderful to be here at your law school. It's really becoming sort of the mecca of international law, and I'm delighted to be able to be back here. Can you hear me? Great. I'm going to present a talk today that is quite primitive in a sense. Just a general description of international law and the problems, one of the major problems we face, and possibly propose a solution and then have you criticize it. Before I continue, I also would like to congratulate your dean, who is now the single dean, if I understand, of the law school, who's really made tremendous strides here in increasing the human rights, the international work that he has been doing before he became the dean. It's great to be here at this law school. I wish many other American law schools would follow suit. Neither the Charter of the United Nations, which gave birth to modern international human rights law, nor the International Bill of Rights, which consists of the Universal Declaration and the two covenants, provide for a human rights court. Of course, the failure to establish a human rights court would not prevent one state party to the convention, to the covenants, for example, to bring cases to the International Court of Justice, charging another state party with a breach of one of the provisions of the covenants, for example, provided, of course, that both parties had accepted the jurisdiction of the court. And although the Universal Declaration is not a treaty, I believe that at least some, if not all, provisions of the Declaration have today become general international law. And if I am right, then also cases relating to the to the Universal Declaration could be brought to the court. Now, the problem with bringing it to the International Court is that to date, little more than 40 countries have accepted the jurisdiction of the International Court of Justice. It's really surprising when you look how many members of the UN we have, almost 200, yet only 40 states have accepted the jurisdiction of the International Court of Justice. Of course, states can agree at any time to go to the court, but still this number is shocking. In addition to the International Bill of Rights, the major normative contribution of the United Nations to the international human rights law consists of a group of important treaties that proclaim basic principles of contemporary international law. Most important of these treaties are the UN Racial Convention, the Convention on the Elimination of Discrimination Against Women, the Torture Convention, and the Convention on the Rights of the Child. Also belonging to this group of treaties is, of course, the Genocide Convention, which was adopted by the United Nations in 1948, so it's really the earliest such treaty we have. In addition to these treaties, except for the Genocide Convention, which operates with its own, let me start this again, except for these treaties, all of them have committees with which they operate, except the Covenant on Civil and Political, on Economic and Social Rights did not have one, but it was added afterwards. The committees are not, however, human rights courts. They monitor compliance by the states parties with their obligations under these treaties by reviewing reports of states that are required to submit periodic reports to the committees. But unlike most UN organs and sub-organs, these treaty committees are supposed to be composed of experts elected in their individual capacities and not as state representatives. Whether and to what extent committee members are truly independent certainly depends on the state parties that have nominated them. Some certainly are, others are not. I served on the UN Human Rights Committee, and we could usually guess who was there in her or his independent capacity and who wasn't, and my sense was that about half of us were independent and the other half was not. But it helps to have at least half who are independent. It affects the whole proceeding and the work of the committee. The Covenant on Civil and Political Rights, the Torture Convention, and the Racial Convention authorize their committees to deal with interstate and individual petitions charging violations by the states parties of their obligations under these treaties. The Racial Convention and the Torture Convention also specifically permit the states parties to refer to their dispute for adjudication to the International Court of Justice if they are not settled by negotiations. And one of these cases, as far as I know, the only one, Georgia versus Russia, dealt with that subject. The Convention on the Rights of the Child and the Convention on the Elimination of All Forms of Discrimination against Women merely provide for a reporting system. Over the years, the UN has adopted many other human rights treaties and declarations. Most of them deal with specialized human rights topics that in one way or another supplement or amplify subjects already addressed to by the International Bill of Rights. Taken together, the UN has thus been able to promulgate a vast body of treaty-based human rights that has laid the foundation of contemporary international human rights law. That is significant when you think that really before the Second World War, there was no such thing as international human rights law. We had some individual provisions of international law that dealt with individuals, but not anything like what we have today, promulgated by the United Nations. Of course, even other UN bodies or organs like UNESCO and ILO also have adopted human rights treaties. Now, the principal difference between the UN human rights system and the existing regional system are the much stronger enforcement mechanisms of the regional systems, whose specialized judicial tribunals are empowered to render binding decisions. At this time, there exist 3 regional human rights courts: the European Court of Human Rights, the Inter-American, and the African Court. These courts operate within the institutional framework of their regional organizations, namely the Council of Europe, the Organization of American States, and the African Union. Each tribunal applies its respective regional human rights treaties: the European Convention, the Inter-American Convention on Human Rights, and the African Charter of Human and People's Rights. These state parties to these treaties have standing to file interstate complaints with these tribunals. The standing of individuals, however, who are victims of violation is generally much more limited. As originally established, the European system limited the standing of individuals in 2 respects. Unlike states parties, individuals had no standing to file a claim with the European Court charging states with violations of their convention rights, unless the state in question has also recognized the individual's right to petition. Individuals also had no standing before the court. That right was reserved to the Commission and to the states parties. It wasn't really until Protocol number 11, adopted by the European states, that changed all this. Not only did the protocol abolish the Commission, it also confirmed individual rights of petition on individuals to appeal to the European Court of Human Rights. The European Court of Human Rights is today the only regional court to confer such powers on individuals directly. The American Convention has since its inception provided for the right of individual petition to its Commission without first requiring a separate state declaration recognizing that right. Such a declaration is necessary, however, for interstate complaints. Individuals, however, do not have the right under the American Convention to access the court directly. The African Charter, which is the most recent one, allows the Commission to receive individual cases which are special cases which reveal the existence of serious or massive violations of human or people's rights. This really means that the jurisdiction of the African Commission is limited to those individual petitions that charge numerous or massive violations of human rights. Over the years, however, the African Commission has been able to circumvent this requirement and to deal with individual violations as such, but on a much smaller basis. The contentious jurisdiction of the African Court resembles that of the Inter-American Court, but the African Court, curiously enough, allows NGOs to file complaints, African NGOs, which is quite an advance. The European Court of Human Rights, of course, is the oldest such body, followed by the American African. So you have an overview. Now, it's surprising, and I recently looked at the latest report of the UN Human Rights Committee, which shows that some countries are almost 30 years behind in filing the report which they are supposed to be filing every 4 years. It's shocking. It's shocking to this extent that it has affected where I wanted to go with this talk today. What I wanted to do and what I'm going to do, and then see what you do to it, is to propose the establishment of more regional human rights institutions, tribunals in different parts of the world. When you look at what's happening in the world and what I just told you about the 3 existing human rights regional systems, there's a whole world where people are totally unprotected by the international human rights system that exists. So, what to do? My proposal really is to try to push for many more regional systems. In Asia, for example, I think one would probably need more than one. One would need sub-regional human rights systems, and in other parts of the world, one probably that remains. But when you look at this picture, you see that probably 2/3 of the world, in terms of numbers of people, are totally unprotected by international human rights protection. So what do we do with it? My proposal first is to push for more human rights, regional human rights. And now one thing you're going to, I'll open it up and have you see what you think about it. My second proposal, something I've been pushing unsuccessfully for many, many years, is to establish regional international criminal courts. So that's where I'm going. Now, when you see the picture that I just saw, which shocked me because I was going to rewrite my talk for today, but I didn't have enough time. So we're going to do that here. Where are we going to go? I've given you an overview of what we have in the world. And the only systems that work, more or less, the European works very well, the Inter-American works better, the African is third in line, but things are happening there. If you could just rewrite all of these things, establish anybody you want to, what would you do? You have to speak, because otherwise I have nothing more to say.
It's going to be an interactive presentation.
Yes.
Is there a microphone? Because we are webcasting, so anybody who raises their hand, we need to get the microphone to so that you can be heard. I'll start us off.
Wonderful. I think we should applaud that Dinner is coming to help me.
So, yes, the problem with the International Criminal Court and the Human Rights Council is that it's a one-size-fits-all kind of approach to a world that is full of diversity. And so your proposal that we look at more regional solutions makes a lot of sense from that perspective. But the other problem with regional solutions is that some regions aren't as far as advanced. You know, the Middle East in human rights is far behind. The human rights.
Did much better without the mic.
It works fine. The Middle East is probably the most far behind, but just even the Africa International or Regional Criminal Court that is being created, the statute for that specifically says that heads of state who commit the kinds of atrocities that you said in the Eurydia case needed to be prosecuted have immunity. And you know, some people believe that the regionalization has created a step back in the march toward human rights enforcement. So my question to you is, if it's got some positives, are you also worried about the negative aspects of regionalization?
Yes, but the problem with the negatives of regional structures is not the system, it's the regional system itself, it's the countries one deals with. And the question then is, how do we get countries not only to join some of these regional institutions, because it depends on them, but also what powers are going to be confirmed on it. I think when you look at the African system, for example, it was quite slow in getting started, as was the European one when it first got started. The European Court did not go into effect until 5 years, when some states by then had ratified the jurisdiction of the court. So it's a slow process, and of course, it's a process that also, it's possible also to shame certain countries into going in, and others will say, look, we are part of this system. So there are international methods, foreign aid and other things, that can get some states to join regional systems, but it's a problem. And of course, the biggest problem is some of the heads of state. And there I can't help, I don't have a sharp enough system to get rid of them. Another question.
Yes, Carsten Stahn from Leiden University. So I think you raised a proposal which I think has a lot of sympathy, and particularly also in the European context. It's been a lot discussed to what extent there have been proposals for a European prosecutor. There are ideas that the European Union should become also more active in developing a regional dimension in criminal law. I think one of the crucial issues is how far you would stretch the jurisdiction. So would it only cover then mass atrocity crimes, so what David Schäfer called the atrocity crimes, or would it also cover, for instance, transnational crimes, organized crimes? So it seems that the boundaries between human rights violations and transnational crime become ever more fluid. So how would you approach this issue?
The way I would approach it is slowly, because our experience, also from the European system, is that if you try to accomplish everything that needs to be accomplished and confer those powers on a regional institution, you're not going to get it. And those that would ratify would not believe that it really was going to work. So I would think you try to establish the most initially very limited powers. I would, however, do one thing that is often overlooked in this. Is the International Bill of Rights, which consists of the covenants and the Universal Declaration, really sets out a basic international constitution, human rights constitution. I would draw for any regional system on those rights. Maybe not all of them at the same time, but some of them, in order not to be, that you would be able to say, well, this is a Western institution. And you can't say that of today, at least anymore, of the covenant. And then I would confer limited powers, initially powers only on states to bring into states claim, and maybe certain other international institutions. Leave open the power of individuals to go directly to an international tribunal, but work for it. But again, if these problems didn't exist and if these questions didn't exist, we wouldn't be here today.
Ambassador Shepard has a question for a comment.
Thank you. Judge, we're going to keep, as professors, asking you, and after my question, the students will start asking you.
I was hoping you would
exactly.
say.
But
they are still more unrealistic, which
well, they have the better questions. But Judge, I want to make 2 points. One, interestingly enough for the audience, Judge Chang Ho Chung, who is a judge on the International Criminal Court and previously a judge at the Extraordinary Chambers in the Courts of Cambodia. He's a South Korean judge, many years on the criminal bench in Korea. He has actually pioneered and led with proposals and advocacy, essentially, to create an Asian court of human rights. He completely embraces your idea that there's an absolutely critical need for a regional human rights court in Asia. And I had the privilege of being at a conference that he helped organize in Korea with the Constitutional Court in Korea. And it was a fascinating display of both intent, but also of the enormous obstacles in Asia because of sovereign prerogatives that would want to be expressed in any discussion for a court of human rights in Asia. It's a very, very tough pull. But it brings out something that I think Michael was alluding to, which is the cultural relativism of individual Asian societies would be brought forth very strongly in any such discussion. And so while there could be a reference to basic documents, I think there would be also a reference to the unique characteristics of sovereign nations and their own cultural backgrounds. So you might want to just comment on that. And then secondly, on your proposal about regional international criminal courts, I can only imagine, just to suggest some of the obstacles, that the International Criminal Court would say, wait, we're trying to achieve universal membership, and we also have a principle called complementarity, where we're trying to build up national criminal codes that embrace the atrocity crimes that are in the Rome Statute. Do you still see a value, though, in having regional international criminal courts, and how you might navigate that issue with the ICC community?
No, thanks very much. Did he, I don't know his name, but if I did, I couldn't pronounce it. Yes. Did he at all think of sub-regional courts in Asia?
There was some discussion of that in North Asian, one, a Southeast Asian court. They might be of different characters.
Yeah, I think that would be probably easier to do, and probably would not confront some of the cultural and ethnic problems that you mentioned. And I also think Asia is much too large, really, for one court. On the issue of the International Criminal Court and Regional Criminal Court, there are lots of issues that the International Court today really doesn't deal with, and would not have jurisdiction. That smaller countries cannot deal with piracy issues and those others. It would be useful. The question that I have in my own mind about is, how would you link that to the ICC? should it be linked or should it not be linked? And I don't know where I come out on that. Maybe you have a preliminary thought on that.
Well, you can fold that into the overall concept of complementarity.
Yeah.
Instead of national courts, you would say, well, there's a complementarity exercise with the regional court.
But then what do you do with no complementary, oh, with the regional, to the, yes, that makes a lot of sense. Thank you. Now, you were ordered, students, to ask questions, from what I heard.
Sure, you use the microphone, because we are webcasting, and they otherwise won't be able to hear it. So. Okay, students, alums, other professors.
Courageous students.
I'll get started.
Oh, good for you, Brooke.
Because this
Will you
to-
introduce yourself?
Oh, my name is Brook Tyus. I am a third-year law student here at Case Western Reserve University, as well as the editor-in-chief of the Journal of International Law. So my question, this area is very new to me, so I would like to know how come the ICC could not, I mean, like, I like the idea of regional centers. So how come these regional centers can't branch off from the ICC as like an umbrella, kind of like how the U.S. courts are here. We have our Supreme Court, and then we have all of our districts. Would that be a feasible idea, where the big umbrella is the ICC, and then they're all under the big umbrella of the entire structure?
Well, this will be really what we just heard in a sense, except it would be coming from those countries themselves. And then the issue would be, how do you relate it to the ICC? And one way to relate it could be that way, that you could see it all as one international criminal law system. The other one would be, and that would be probably easier to put together if they were not linked, because also the jurisdiction of the ICC is more limited and could not necessarily deal with, would not have jurisdiction over some of the things a regional criminal court would have.
Thank you very much. So Jonas Grimheden from working for the European Union. A couple of reflections and a question maybe, if I may. Thinking about the ASEAN, the 10 member states they have developed, and along the lines you said, something that we couldn't understand or conceive of 20 years ago, and now they have a declaration, they have a monitoring committee, and there are lots of flaws. If one looks at the text of the declaration, there would certainly be words that would be compromising the international standards or the global standards. But again, it's there. It has some problems, but with the right incentives, with the right accident or incident that might cause the member states to be a bit braver, it's there. So there's one way of being. There's possibility to be optimistic about those things in the ASEAN region, at least. In Europe, where I'm from, I know, just like you said also, that the government was extremely skeptical of when the European Court of Human Rights was set up, and Sweden was a fairly sort of pro-country, pro the establishment of the court. But one of the ministers referred to the court as the playhouse of the judge, of the Swedish, or the judge nominated on behalf of Sweden. And my question is, Russia has been problematic in the context of Council of Europe lately, and as I understand it, they are sitting on 23 million towards the budget of the Council of Europe, 23 million euros. So how could we ensure, if we had this regional or indeed at the global level, how could we ensure that the funds are there, that the funds do not become a bargaining chip of the government? So to make sure that the independence, at the same time, there has to be transparency, of course, and good use of the money, but how could we ensure that there is an independent and continuity of these monitoring bodies if the government wants to be restrictive on the purse, so to say? Thank you.
By the funds, you speak of the contributions that individual states would make to the tribunal. And you mentioned Russia. It's a very serious problem in Europe right now. Also, compliance with judgments of the European Court of Human Rights. I think the good fortune in many ways that the European system had initially when it was started was that no really major powers were part of it. So it's much easier to deal with smaller countries to establish such systems, even though France was there from the very beginning, but I won't say whether France is really a superpower or not. And it took quite a long time to even get Britain into the system in Europe. I don't have an answer to how you. The only answer I would give you is that, of course, you couldn't force any state to join the organization in the first place, and then you would expect that they would make the contribution that has been decided for them. Shaming sometimes works, especially with important powers, when you say they've joined and now they don't want to pay up, and use a lot of propaganda, and that's the only thing I can think of. But it's a serious problem. And the failure of Russia to really go along, even though they wanted very badly to join the European system.
Thank you very much. Franklin LeBeau, professor at Baldwin Wallace University. I teach on a lot of topics related to Asia. One of my favorite areas has to do with the environment. A country like China equates things like environmental rights with a notion of people seeking human rights, which they then see as a threat to the state. So if you even have something like the Ministry of Environmental Protection in China, and you take a look at their very weak enforcement powers, their inability to even require provinces to stop engaging in toxic waste production, and essentially leaving it up to the regions, the provinces in China, to make their own rules and police their own systems, which they do very poorly, most of them being controlled by local interests. I wonder, how do you get a country like China to be interested in buying into a system which really flies in the face of its own model, its own approaches? It basically relies upon naming and shaming of perpetrators of rules, or providing incentives, carrots of all kinds, like tax incentives, to get people to actually comply. But to them, human rights is the number one threat to the security of the state. And when people begin to even text about organizing together to, protest the next toxic waste polluting site in name your region, the first thing that happens is tanks roll up. So I find the idea fascinating, and I appreciate the question, but I'm really curious about some of the big players in the region that it's completely against their basic system of understanding the law. So I would much appreciate your thoughts on that.
You are an optimist if you expect me to come up with a solution. When you deal with China, first of all, I wouldn't start with China. And they wouldn't start with us if I were organizing it. So that would be a serious problem. One really has to deal with, to some extent, with more or less like-minded countries in terms of their systems, their commitment to certain general universal principles. China is a very big country, and it takes bigger countries a long time to join. So look at the United States. It took us 20-some years, it took us almost 30 years to ratify the Genocide Convention, 20 years to the Covenant, and we haven't ratified many of the important human rights treaties yet. So it's not just China or Russia, it's also the United States. As a matter of fact, some big countries ratify it and then don't comply. We try to not ratify and not comply. But when we ratify, we do comply and at least try to. So I don't have the answer for China. And Asia isn't easy, even if you pick region. If you take ASEAN, for example, which is showing that cooperation is beginning to work. That might be something I thought initially that would be probably the starting group to work with, to expand the powers. They haven't even established any sort of direct judicial system at all. So that's where you would start with very small possibilities for accessing some international tribunal. But China, I don't have an answer. And I don't know enough about Asia really to say.
My name is Ananya Malavarpu. I'm a student
Could
here.
you speak a little slower?
Sorry. My name is Ananya Malavarpu. I'm a 3L student here at Case Western. My question is, when it comes to labor standards, specifically child labor or just undocumented labor or even or labor conditions, how exactly should the international government or international governance go about enforcing that more? Because we have this idea, and corporations do say they are trying to better the labor conditions of their workers, but we don't really see enforcement of that on the ground level. So what do you propose, or what are your thoughts on how to go about enforcing those mechanisms better?
Well, first of all, I wouldn't start with the assumption that they are not enforceable. You should look at the European Social Charter, for example. You have to deal with social and labor rights and economic rights to some extent differently than you deal with civil and political rights. You have to make that distinction in terms of enforcement. But it is not true that no economic or social rights or cultural rights are enforceable. A different method, but different approaches. And I think the European Social Charter seems to work quite effectively. Take a look at it. It's harder to do, but if it has to be done, the ways are going to be found. But you have to recognize that there are distinctions. In the United States, initially, we simply said that social and economic rights are not at all human rights. I think we're learning. And that would be sort of the first step.
Hi, thank you, Judge Bergenthal, for your provocation. I teach international human rights law and international business transactions. My name is Tim Webster. I teach here. And my question is one of sequencing. So you're suggesting an international criminal or international human rights law mechanism on a regional level. I think the experience, certainly in Europe and other areas as well, has been, frankly, human rights comes last in the process of integration. So you have economic integration, you may have some degree of financial integration, and once there's a degree of mutual trust among the member states, and this is certainly the case with Europe, then you can move to what I think is traditionally perceived as a second order issue, which is human rights. Now, I say that as someone who believes in human rights, but has also seen enough of how international organizations work that countries, at least countries in Asia, which are the ones I'm most familiar with, are, if anything, you're going to have economic integration first, maybe human rights integration later, if at all. So do you see a role for economic or other kinds of integration before you see this, what I would see as a leap towards something like international criminal law or international human rights law integration?
Well, you know what is interesting, when you look at the European system, the European Convention of Human Rights was drafted in 1951, before the European Coal and Steel Community was established. So the integration here moved almost simultaneously. And in some ways, the European Convention system was already there working effectively by the time the European Union was established. So it doesn't follow. But I think in other parts...
The Human Rights Convention didn't take effect until 1960, 1959. So you still have a 10-year block.
No, 58.
59.
Well, 59. But when did the European Union come into effect?
51. The economic steel.
Yes, but that was a very limited subject.
Right.
But the European Union, as we have it today, was much later.
Okay.
No, but the point I think that you are trying to make, with which I agree, it probably depends what regions you start with first. Whether you have, in Europe, because of the European experience in the Second World War, human rights were deemed to be much more significant and important than any other rights. And that made it possible to re-establish a pioneering system. It took much later in other parts of the world. And that'll probably be the case also with integration of international human rights in systems in other parts of the world than in Europe or pioneered. That's a reality one has to live with and take into account when one thinks of it. But the ASEAN system it could be a beginning in Asia. I don't know how many countries, is it 8 or 10? That could be, and they've already had a declaration on human rights. And that's very important. So if you start there, you suddenly find other countries are going to be also interested to belong to this important system. So it can work. But when you're dealing with human rights, and that's not really a criticism of what you say, you have to believe that it's going to, that it has to happen. And then you're going to be confronted with all kinds of buts, and you simply live with it and try to overcome them. That's sort of the only way. Otherwise, you'll never establish anything. If you had asked somebody before the Second World War whether there would be such a thing as international human rights, the European system, the inter-American system, the African system, they would laugh at you. And suddenly, of course, it took genocide and the Holocaust to get it done, and I don't wish that on any other part of the world.
Judge, let me ask a question that's the Dean's prerogative to ask the final question here to segue us into the main topic of our conference. And it's a question I asked you yesterday on the radio, and that is, with your long history in the human rights field, and you've seen the evolution of human rights, if you were sitting on the U.S. Supreme Court in the Jesden versus Arab Bank case, how would you rule on the issue of whether corporations can be held responsible for human rights violations under the U.S. Alien Tort Claims Act?
I would come out the same way you came out yesterday.
Tell us why.
Well, I would say that corporations certainly can be held liable. The notion that, for example, corporations cannot violate international law is something that had never occurred to me. But it occurred to the Supreme Court, and I suppose that's relevant. No, I do think one has to conclude that we live in a different world, that corporations today affect everything that's going on in the world, and that they have to be internationally regulated, and they should be, and consequently there's no reason why they shouldn't be, international law shouldn't apply to them as much as to individuals. And of course, corporations, the problem, and you pointed it out very well, that very often you cannot get to the corporation because individuals get punished, but the corporation continues. And you've seen this in Germany, for example, where the two corporations in Germany that were manufacturing gas for the crematoria are still working. And they are there, and I saw an interview with them, and I had this feeling they were a little proud of the fact that they were still there. So I think, though, I would leave it to you to explain it as well as you did yesterday. Thank you.
All right, can everybody give us a for the next panel, for you to network, for the students to get to know the panelists and the experts, and the alums to get to know each other and the experts. That's part of what we do here. You can take your discussions here, where we have some food in the back of the room, or go back to the rotunda, but we will start immediately at 10 o'clock with our next panel.